Hi, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan, and today we continue our video series designed to educate the public, so please subscribe to our channel. I want to talk about marital property versus separate property, a topic which we've covered extensively in video format, but today I want to cover a detail of that, and that's marital versus non-marital and whose name the property's in. Let's say we're talking about an item that lends itself to a title, like a vehicle. A vehicle has a title, and the title may say it's in mom's name or it's in dad's name. How does that impact things? Generally speaking, if you've got an item that you had before the marriage, let's say it's a car, let's say it's a classic vehicle, you've cherished it for years, it's in your name, it's titled to you, before you got married you had it, later on there's a divorce, your spouse knows it's the only thing you really care about, so therefore they try to take it away from you. Will they likely get it? The answer is probably no. They're not likely going to get it. The court's going to be wise to the fact that that was a prior acquired asset, it's titled to you, and therefore, in that circumstance, you'll probably end up getting that asset. The question becomes, what happens if you take that vehicle and you title it to both of you later on? You get married and you say, I want to show good faith. I'm going to title this to my husband or my wife or to both of us. What happens? Well, in that scenario, what you've done is you've made a gift to the marriage. And now, yes, it is up for grabs, in a subsequent divorce. You have to understand one thing, though. The title of something doesn't necessarily dictate where it's going. So suppose you bought the classic car after the marriage. But for whatever reason, you titled it to your spouse, but you want that car in the divorce. Does the fact that you've already titled it to someone else mean you won't get it? And the answer is no, that doesn't mean that at all. Title, with respect to the rest of the world, goes to ownership as concerns that person and the rest of the world. It does not apply to the marriage. Think of it this way. Think of marital property as that both the husband and the wife own every molecule of everything they've collected in the marriage. So if they own this baseball, it's not like she owns the bottom half, he owns the top half. That's not how it is. Every piece, every molecule of it is owned by both. You can't split it up. So what happens? In a situation like that, it doesn't matter who it's titled to. We still have to split it up. Why? Because it's purchased during marriage. It's a marital asset. Now, what do we do with things we can't split up? Obviously, we have to determine values. We can't split up the item, perhaps, but we can split up the value of the item. So if we're talking about, for example, a vehicle that's titled to her, but it's going to go to him in the divorce, we look at that vehicle. If that vehicle is worth $5,000, you know what it means? $2,500 is hers, $2,500 is his. If he's keeping it, and she's going to sign that title over to him, he's got the whole $5,000 value, and that means we owe her $2,500. We got to either pay her cash, we got to give her another asset worth more so to make up the money, we got to take on $2,500 extra of debt to balance it out somehow, some way. We got to balance that out so that it's as equal as humanly possible. Now, if you have any questions about your case, reach out, and we'll be glad to help you out.